Is it possible for your ex-spouse to make off with your life savings?
Well, shockingly, it is. Even if you have a will. Divorce attorney Cynthia Diggs and financial expert Rich Rosso are here to explain how in the world that could happen. So explain it to us. A 401k, an IRA, something like that. How could your ex get it if you're split up?
Well, what happens in Texas in a divorce is that with respect to the will, if you write a will during the marriage and you designate your spouse as the beneficiary, Texas law, unlike some other states, provides that if that's the will that's still in existence when you pass away, they will disregard your ex-spouse and give your property to your other heirs. However, there could be a problem with life insurance. We have a similar statute with respect to life insurance benefits, but it can be superseded by federal law, which doesn't have this exception. Most large employers are governed by federal law, and so if your life insurance comes from your employer and it's governed by federal law, and you've designated your ex-spouse, that's the person who may get the proceeds of the $200,000 life insurance policy.
So you have to be really careful and make sure you know who your beneficiaries are, because I'm sure there's plenty of things that you forget about that you even have out there.
It's one of the most common mistakes that you see out there. And I have to remind clients consistently, did you check your beneficiaries? And hey, it just happened to me recently. I'm embarrassed, financial planner for 20 years, and I didn't have my tax person goes, hey, you don't have a beneficiary on your retirement account. This can happen to you. So you want to go directly to your custodians and your life insurance companies, call them, go to your HR department, and make sure that you have the correct beneficiaries, or fill out a new form, receive a copy of that form, keep it with your important documents.
Get organized. Make sure everyone in your family knows in case something happens and they can't find it. It makes it a whole lot easier, doesn't it?
Rich, it does get complicated, though, if your children are still minors, right? I mean, if you, like, let's say you say, okay, I'm split up from my ex-spouse, so I'm going to take him or her off of, to not be my beneficiary on this big sum of cash that I have, and I'm going to name my kids. But if they're minors, does the spouse get it? I mean,
well, it seems natural to name your children, right? But if they're minors, they can't receive the asset. So there has to be guardianship if it goes through this whole process if it's not done correctly. So usually there could be a trust that's set up as beneficiaries, but you need to be very careful as trust as beneficiaries, and it has to do with how the assets pass on from you to your children. You want to be able to have them take that money out over their life expectancies. So we see a lot of mishaps when people name trusts or their estate as beneficiaries, and they totally throw away some of the good stuff that allows the postponement of taking that money out of your, or at least letting an IRA continue for the lives of the beneficiaries.
Cynthia, is this a lot of work to change your beneficiaries when you get divorced? What all do you need to be prepared to do?
You know, people are sometimes rather exhausted after divorce. Naturally, their financial resources are stretched. But this is something that really isn't that complicated. You just have to be proactive in changing things. And for example, despite the fact that the law disregards your ex-spouse as the beneficiary under the old will, once your ex-spouse is no longer the beneficiary, who does the money go to? You need to stop and write a new will and reallocate your assets. And at the same time, most lawyers who write you a will also prepare a power of attorney, they will prepare medical directives, and you don't really want your spouse listed on those either, and you don't want no one listed. You want
so you got to redo everything.
Someone. You need to redo everything.
I would venture to guess that a very large percentage of the people watching right now don't have a will, or they haven't made one for a long, long time. What if someone doesn't have a will? Then who decides where the money goes?
The state decides. I mean, for the most part, the state decides where the money's going to go. Even if you're not subject to estate tax, do you want to dictate where your assets go, or do you want the state to do it? So you should have a will, regardless of the size of your estate, so at least it states your intentions.
Is it satisfactory to do it through one of those online things that costs, you know, $69? Is that, will that be accepted? Is that okay?
I really can't recommend that. You know, legal history is full of examples of handwritten wills. We call them holographic wills that stood up, but it's also full of examples of handwritten wills and fill-in-the-blank wills that did not stand up. Go to an attorney and get the advice that you need and do it in the best possible way.
Cynthia Diggs, Richard Rosso, good to see you. Thanks for helping us. These are life changers, so I hope people listen closely to what you had to say.